Okay, I want to spend a few minutes in this video talking about how living trusts work. I felt the need to do this video because I've had so many clients over the years ask me questions about how living trusts work that suggest to me that there's a lot of unnecessary mystery to the subject. I actually think in just a few minutes I can walk you through how trusts work and make it perfectly clear to you. So, but let me first of all just remind you that it's certainly my opinion, and that opinion is shared by a lot of others, that a living trust is far and away the best way to avoid the probate process. And that's true for several reasons. The reason a living trust is the best way to avoid probate, first of all, is because it is totally private. Nothing with respect to your living trust gets filed with the probate court. Something I really like about a living trust is that it works regardless of who dies in what order. There are a couple of other ways to avoid probate, things like using beneficiary designations and sometimes using jointly owned property, but all of those techniques require people to die in the right order, and we know from our experience that that doesn't always happen. In a living trust, we can design it so that you get the outcome that you want in every possible circumstance, no matter who dies in what order. A living trust works in all 50 states and even in the U.S. territories, and that is actually very important if you own property in more than one state. We have a lot of clients that own property in other states. A lot of clients own property in Texas and in Florida. And if that's the case, that means that if you don't have a living trust plan, then when you die, you have to have a probate proceeding not only in Arkansas, but also in all the other states where you have property. We eliminate that problem with the living trust. We talk more about this next issue in another video that we've done, but I just want to say that one of the great things about a living trust is that you can build into your living trust plan protection from divorce and from lawsuits and bankruptcy for your heirs. That's a feature that you can really only effectively do in a legal document like a living trust. You can't do that with jointly owned property, and you can't do that with a beneficiary designation. The other thing I really like about a living trust plan is that it keeps you in control at all times. That's not true with other ways of planning. For example, if you create jointly owned property, you really give up control, because now to transfer a title to that, to sell it, or to give it away, you have to get the other joint tenant to agree. That's not the case in a revocable living trust. With a living trust, you retain 100% control at all times, and you can change your mind about the plan at any time. There is no other planning tool that gives you all of these benefits. So it's worth understanding, it's worth taking a few minutes to understand how a revocable trust works. I've created a little animation here to illustrate the concept of a living trust. But let me first talk about how your property would pass if you did not have a living trust. So I have a box here that represents your property, and let's suppose then that when you die, that property has to go somewhere. It can't just remain in a state of suspended animation. The title of that property has to get transferred to somebody. And so if you own property that's titled just in your name, that property, with a couple of exceptions, is going to have to go through the probate process in order to find its way down to the heirs. Now, let's take a look at how that would work if instead of having the property titled in your individual name, that property was titled in the name of your living trust. It's the same property. Let's just move the title over into your living trust. Then when you die, what we realize is that that property is going to pass under the terms of the trust, just as it would if it were a will plan, except the problem with a will plan is that in order for a will to be valid, that will has to be admitted to the probate court and go through the whole probate court process. That's not the case with a living trust. So when I transfer property to a living trust and then pass away, that property can pass directly to my heirs without having to go through the probate process. The best way I've come up with for explaining to our clients here how living trust works is to ask our clients to imagine that their living trust is a piece of furniture, a chest of drawers, like you have it. Probably everybody watching this video, I'm guessing, has one of these somewhere in their house, probably in the bedroom. So if you think about your living trust as a chest of drawers, the way it works is when you first create your living trust, you actually create the entire piece of furniture. The whole, you build the whole thing, build all the drawers into it. And then after you've built it, that is, after you've created the legal document, you've signed it, and it becomes a valid legal trust, then you open that top drawer and take all those assets that we talked about and transfer the title of those assets into the living trust, so that the record title is in the name of the trust, not in your individual name. That means that we would deed your house over to the trust. We would take your brokerage account, transfer the title of that to your living trust. Any real estate you have, we would transfer that. Almost all the assets that you have, we would transfer to the living trust. And what I'm describing here, kind of in a metaphorical way, is to say we're going to put all those assets into the top drawer of your chest of drawers. And they're going to remain there as long as you're living. They're going to remain entirely under your control, because in probably virtually every trust we've created, our client is the trustee of their own trust, so they have total control over those assets. The decision to sell an asset, the decision to keep an asset, the decision to give away an asset, the decision to take an asset out of that top drawer and spend it on a trip around the world, if that's what you wanted to do, is always made by you, the client, because this is your living trust and you have 100% control over it. We've had clients who have been reluctant to create a living trust because of a fear that somehow by transferring property into a trust, they lost control over that property. That is not true. That's not true. As long as you're living, it is your trust. It is a revocable trust. That means that you can open that top drawer, take that property back out any day you want to. But then what happens is if you become incapacitated, we have provisions drafted in the trust that say that the persons that you choose take charge of the trust and manage it for your benefit during the period of time that you're still living, but are not able to manage it yourself. Maybe you've had an accident and you're in a hospital in a coma. Maybe you have some kind of disease that's resulted in your not being able to manage your property. But clearly the terms of the trust say that property has to be managed for you, for your benefit, by the people that you named. And they can do all of that without having to go through any kind of guardianship proceeding in the probate court. Then when you die, what happens is we open that top drawer, we take a snapshot of what's there, figure out what it's worth, make sure that all of your bills get paid, make sure that your taxes get paid, and then based on the instructions that you drafted into your trust, we open up that next drawer. Maybe that next drawer was created for the benefit of a spouse. We then move all the assets down to that next drawer, and those assets remain there, typically for the spouse's benefit as long as the spouse is living. And then, whenever the spouse passes, we open up the second drawer, take everything out, and put it down into the third drawer for the benefit of your other heirs. So this is just a way of thinking about how trust works, but I actually believe that if you can kind of get your mind around the idea of your living trust as this kind of a piece of furniture with drawers in it, it's really a good, it's a valid way of understanding how living trust works. Now, what we do here for our clients is we'll create graphics using PowerPoint to help our clients understand how the plan works. And so I've created an example here for a client who we named Sam, and Sam has a living trust, and what Sam is going to do in this trust is take his life insurance and change the beneficiary designation on that so that his trust is the beneficiary of that. We're going to take his bank accounts and transfer those into his living trust. We're going to take, other assets that he has, a brokerage account, real estate, all that, and we're going to transfer that into this this living trust that we've created for him. We're also going to do something else I need to mention, and that is we're going to create what we call a pour-over will. It's just a regular will, a very simple will, but it only does one thing. It's a will that says, when I die, if there are assets that I own that for whatever reason never got transferred into my trust while I was living, I hereby will those assets to a living trust. So the living trust really becomes the one document that you look to see where everything is supposed to go when a person passes. The will is just a kind of a cleanup device. I like to tell clients here that pour-over will, I think of that pour-over will the same way I think about the airbag in my car. I want it to be there. I want to know that if I need it, it'll deploy properly, but I really don't have any plans to really use it. In fact, I would prefer to not use it. So that's the case actually with almost all of our clients. It turns out we never really need to even open up the folder that has the will in it because our clients' trusts are properly funded. So we're going to transfer all these assets into the trust, and then whenever our client passes away, the assets are going to pass without probate down to our client's son, whose name is Anthony in this case, and in this case, rather than having the assets pass outright and free of trust to Anthony, there were some reasons why we determined it was actually better to have the assets continue to be held in trust for his son's benefit. Actually, his son was a minor, and in his plan documents, we were able to identify the individuals that we wanted to serve as Anthony's personal guardian until he reached the age of 18. And of course, the way that would work is the guardians would then sit down with the trustees of this trust, who we also named. In this case, we named a friend, Joe, and if Joe couldn't serve in that capacity, we named a bank and trust company as a backup. So the way that would work is that after Sam dies, the guardians would sit down with the trustees and have a conversation, work out a budget based on the assets in the trust, based on the ability of the trust to generate income so that we could plan for Anthony's financial security over his lifetime. So that's how a living trust plan would work for an individual. Now, in this case, we have another example of a living trust for a married couple. It works the same way. It's still the same concept of the chest of drawers where we have all the assets of this couple being put into the top drawer, if you will, of the trust, the top drawer of the chest there, and they named themselves as the trustees, and they named the surviving spouse as the successor trustee, but at a point when neither of them could serve, they named a sequence of other individuals who would serve as the trustees. And the trustee is the individual who, let's say the individual or individuals, because it can be more than one, who have the responsibility to take charge of the assets and manage them for the benefit of the beneficiaries. In this case, the beneficiaries are John and Phyllis because they're still living. But if John dies, then Phyllis is the beneficiary, and then later on, as we move down through the plan, then their heirs become the beneficiaries. But the trustees still have that responsibility to manage the assets for their benefit. Now, one other thing I want to point out here in this plan is that both John and Phyllis have individual retirement accounts. They have IRA accounts, each of them, and you'll notice that we did not transfer those IRA accounts to the living trust. And the reason for that is because the the IRS has clearly taken the position that if I transfer the ownership of my IRA account into the living trust, that's treated as if I took all the money out. And we all understand that if we take all the money out of an IRA account, we have to pay the income tax on it. So in this plan, we had to coordinate the distribution of assets upon death that are in the living trust and the distribution of the assets that are in the IRA account. And I'll show you in a second how we did that. So in this case, when John passes away, and as I tell all my clients, in all of my examples and illustrations, us husbands always go first in the illustration. So in this case, John dies first and Phyllis is the survivor. So what's going to happen is we're going to take all the assets out of the top drawer of our little chest of drawers here, and we're going to move it down. But before we do that, we're going to do something with the IRA account. And what we did in this case with the IRA, if you see there, is we rolled the IRA over into Phyllis's IRA so that she could leave it in that IRA and would not be required to take out her required minimum distributions until she reached the age of 70 and a half. So we did that first, and then the next thing we did is we took all the assets that were in the living trust and moved it into that next drawer, and we named that drawer the marital trust drawer, if you will. And this was a really simple plan. This was a marital trust that had no strings or restrictions, but all this happened without any kind of probate proceeding. But in this case, Phyllis has full and complete access and control over the marital trust because, you recall, she is still named as the successor trustee of the trust. So Phyllis is entirely in charge of managing the assets in the marital trust, and she has full and complete control over her IRA account. And everything stays just like that as long as Phyllis is living, unless Phyllis becomes incapacitated. And if that happens, then the successor trustee that we named, in this case it's Clarissa, steps in and takes responsibility for the management of the assets in the marital trust, but again, for Phyllis's benefit. And the other thing that happened is Clarissa was also named as Phyllis's agent under her durable power of attorney, so that Clarissa now, because she's now wearing she also wears her agent under the durable power of attorney cap, she now has the power to manage and control the IRA account. That's why, you know, we have to explain to clients all the time that because there are assets that we can't put in the trust, we have to have these durable powers of attorney out there, because if I only have a living trust and nothing else, then we still have to go to probate court and have a guardian appointed to name somebody to manage the assets that we really can't put into the living trust. And that's where the durable power of attorney comes in. So in our view, a durable power of attorney is an essential part of any living trust estate plan. Anyway, Phyllis now has full and complete control of the assets, including the marital trust and the IRA, but when she passes later, then the successor trustees take over, make sure that her bills get paid, her taxes are paid, and there we have to once again dispose of the IRA. The IRA has to pass, and what we did in this case is we created a trust for their son Corey and their daughter Clarissa, and we provided that the IRA would be divided equally between the trust that we created for their two children. You'll notice that in this instance we did not leave the IRA to the children directly or outright. We left the IRA to the children's trust, and the reason we did that is because we wanted to make certain that this IRA, which represents a significant part of John and Phyllis's net worth, we wanted to make sure that that IRA was protected from their children's divorce. We wanted to make sure that it was protected in the event that either one of these children ended up, being sued in a lawsuit or going bankrupt as a result of some kind of a business failure. So we did that using using a schedule that was attached to the beneficiary designation at the brokerage firm where the IRA was kept. And then all the other assets that were in the marital trust just got divided into the two separate trusts. So if you remember our chest of drawers, this would be like the third set of drawers. So in this case, there would be not one drawer down at the bottom of that chest of drawers. There would actually be two separate drawers, one for each of the Jones children. And what those trusts do, the way we've designed it here in this case, you don't have to do this, but I think it's a good idea to do this, is to design those trusts so that each of these children have lifetime divorce protection and lifetime lawsuit protection and lifetime bankruptcy protection, so that no matter what happens to them throughout the balance of their life, the assets that these children are inheriting from John and Phyllis come to them in a way that provide lifetime financial security for them. It can't be taken away in a divorce or legal judgment. So the other thing that happens is that by designing it this way, we have language in these trusts that not only provide that lawsuit and divorce protection that we want, but it also allows the IRA to be stretched out over each child's lifetime based on their age at the time of Phyllis's death. So what that means is that each of these children don't have to come in and take all those assets out of the IRA and pay income tax on it. They get to leave the assets in except for their required minimum distribution. And because this is an inherited IRA and these children are relatively young, that means that there's a period of 30 or 40 years here where that IRA will continue in existence. The assets inside the IRA will grow on a tax-deferred basis. So the IRA becomes a very important part of the children's lifetime financial security. And all of that can be done while still providing this divorce and lawsuit protection that we talked about. So that gives you kind of a I think a quick and dirty explanation of how revocable living trust plans work for individuals and how revocable living trust plans work for a married couple.